Hello everybody, I am Anu Priya, Assistant Professor in Rai University, and today we'll start with the fourth lecture series of Transfer of Property Act. Let's get started. In this lecture series, we'll cover from section 15 of the Transfer of Property Act. The Transfer of Property Act, section 15, deals with the transfer to class some of whom under section 13 and 14. Basically, for this section, you have to consider section 13 and 14 for first. In the previous lecture videos, we have already completed section 13 and 14 for your reference. But for here, let me briefly conclude this section 13 and 14. Basically, section 13 deals with transfer of property for unborn person, and section 14 deals with transfer against the rule of perpetuity. So this is what section 13 and 14 basically deals with. With the reference of the section, I'll deal section 13 14 for the better understanding of this section. If on a transfer of property an interest therein is created for the benefit of a class of person with regard to some of whom such interest fail by the reason of any of the rules contained in section 13 and section 14. So what is actually the term used here is benefit of the class of person. What the term class of person basically means? So the term class of person is actually the group of person. So if there is a benefit or interest transferred on the behalf of class of person or a group of person particularly with regard to some of whom such interest fails. So the interest basically is fails, or the rights basically fails the transfer on the behalf which are the rules contained in 13 and 14. For example, let's take the example of section 13 basically. For transfer for the behalf of unborn person. So if A is a person who wants to transfer a property to a person X who is unborn. He is not yet in existence basically, not even the womb of mother. So how the transfer can basically affect over here? Because section 5 of Transfer Property Act is basically deals with the transfer of property act can actually happen if there will be inter vivos transaction, means that the transfer will happen between two living persons. So over here, what we are dealing is that the transfer on the behalf of unborn person. So this will came effect by the rules of section 13 is basically by the process that a person needs to create a life interest to a living person. So A at first have to transfer the property to B, other person who is living at the time. So the life interest will create on the behalf of B, and after B the property will transfer to X who is unborn. So this is how the transfer is actually carrying on the convey to unborn person by the virtue of section 13. So if the transfer fails, to X or unborn person, for example, A is a person who wants to transfer the property to the son of B, X and Y. Son of B, X and Y, and as soon as X and Y reach the age of 18 years, the property transaction will came effect. So A transferred to B, life interest created in that property of B, and after that the property will absolutely transfer to X and Y. So over here the absolute transfer is very important. If a property is transferred to any unborn person, the transfer must be in absolute. All the rights, including the rights of transfer, including the right of alienation of that property, should be transferred to unborn person. So if B, in the lifetime of B, X born, but Y did not born. So what will happen over here? If X and Y both weren't born, what will happen? That property will revert back to A. But over here, what is actually happening? X get born and he is of 19 years, but Y did not born. Then the transfer of the interest over here is fails. On the behalf of Y, the interest fails, but on the behalf of X, it is valid. So the property in this case will not revert back to A. What will happen? The property will transfer to X perfectly. This is what this section actually dealing with. That if on a transfer of property an interest there is created for a benefit of class of person. So who are the class of person over here is X and Y. with regard to some of whom such interests fail. So with whom regard the interest is failing out? In the regards of Y, the interest failed because Y did not bond. Next is by the reason of any of the rules contained in section 13. So what are the rules contained in section 13? That property should be absolutely transferred. But why, as soon as the death of the B happened, why did not bond? So over here the interest failed on the behalf of Y by the rules contained in section 13. And this will also follow the same in 14. Such interest fails in regard to those person only and not in regard of the whole class. So with regard to the Y, the interest will fail, but with regard to X, the transfer will be absolute. It did not fail at all. So this is what this section is dealing with. The next slide deals with section 16 of Transfer of Property Act. The Transfer of Property Act, section 16, basically deals with transfer to take effect on the failure of prior interest. So in the same example, let's take the same example that A is a person who wants to transfer the property to unborn person, for example X and Y. So he created the life interest to B. So what is this section is basically dealing with is that there is a very landmark case about this section, that is the case of Girish Dutt case. You can check it out for the better understanding of this. So what happened in that case basically is A is a person, he transferred the property and created the life interest of B in that property, and further on he laid down that if your son will bond, the transfer will be absolute. You can transfer the property to your son. But if the daughter will bond, the transfer will happen, but there is not absolute transfer. The daughter will not annihilate that property. The daughter will not further transfer that property particularly. And if both daughter and son weren't born, then the property will transfer to your nephew. This is what the section case law deals with. So what happened over here that when this come to the Supreme Court, what actually happened over here is that the Supreme Court held that in this case, what is actually going to happen is that for the son, behalf of the son, it is absolute, because the property he can transfer, he can annihilate that property. But when it comes to the interest created on the behalf of daughter, what is actually happening? There is no right of annihilation. So what is this? This is actually the failure of compliance of section 13 of the Transfer of Property Act, because you cannot transfer the property to the unborn person without transferring the absolute right over that property. So over here the interest fails on the behalf of daughter, but further on the transfer which is on the behalf of nephew was complete, but in between that line the interest actually fails. So over here what this section is actually relating that where by the reason of any of the rules contained in section 13 and 14, an interest created for the benefit of a person or a class of person. So the interest is created on the benefit of person or class of person is basically the group of person, fails in regard to such person or whole of such class. So the procedure is actually failed on behalf of daughter. So this will happen. No, if this will not happen, then that will happen, that the property will transfer to son. If son did not bond, then the property will transfer to daughter. If daughter did not bond, then the property will transfer to your nephew. But the interest which is created on the daughter was failed. So over here in between the transaction procedure, the interest is actually violating the section 13 of Transfer of Property Act. In that case, what will happen? Upon failure of such prior interest also fails. So the whole transaction will fail out. So the transfer is basically revert back to the person. Now comes to section 18. I'm skipping section 17 over here and came to section 18 basically because after that you will understand section 17 better way. So it is basically deals with section 14, 16 and 17 overall. So we have already read about section 14 and section 16 in the previous slide. So in this slide you can see the Transfer of Property Act whereas talks about that the restriction in section 14, 16 and 17 shall not apply in the case of transfer of property for the benefit of the public in the advancement of religion, knowledge, commerce, health, safety, or any other object beneficial to mankind. So, overall, what this section concludes is that whatever condition or whatever things we have read, that in particular way, that if this will happen, the transfer will fail, the interest will fail. This section is actually subject to the provisions we have already done. This section is basically exception to the restrictions which are imposed by sections 14, 16 and 17. So if there is any restriction is imposing by section 16, 14 and 17, this section says that if that transfer is for the benefit of public, what kind of public benefit it may be? It may be for the religious purpose, it may be for the knowledge purpose, it may be for the commerce, health or safety purpose, whatever it will be. So for these reasons, for the beneficial of mankind in general, so in these cases, this section will prevail and the transfer will not cancel out. The transfer will be valid. It will not become void by the virtue of section 14 restriction or 16 restriction or 17 restriction. Let's move to the section 17 of Transfer of Property Act. So over here, what the Transfer of Property Act section 17 basically deals with is about the direction for accumulation. So this accumulation or section 17 is also known as doctrine of accumulation. So doctrine of accumulation, what it actually deals with? What the term accumulation basically means? It means to accumulate, to collect something. So what collection is basically dealing with? The collection of certain rights, the collection of certain monetary benefits and all. So what this section is basically deals with, where the terms of transfer of property directs that the income arising from the property. So it basically deals with the income arising from the property shall be accumulated either wholly or in part during the period longer than the life of the transferor or the period of 18 years. So whatever will be maximum, that accumulation right will continue. For example, if A is a person and B is a person, and A transferred the property on the behalf of B, that for specific period, for 25 years basically, you have to accumulate certain amount of money from this property. For example, 50% of the income from which is be receiving from that property, basically you have to transfer that 50% amount or accumulate that 50% amount and transfer it to someone C. For example, you have to transfer that amount to C. So this is overall what section accumulation doctrine is basically deals with, that A transfer the property on behalf of B, and the condition is that for 50 years you have to accumulate the money and you have to transfer that money to C. Okay, this is what doctrine of accumulation is. But the next further thing is that this can continue to the life of the transferor and or maximum 18 years. What is the thing which prevail over here? 18 years or life interest of the property. So what this section is actually telling us about, for example, A transfer the property for behalf of B for 25 years. Basically he's told that you have to continue accumulating the property's income 50% and give it to C for 25 years. A is alive for 25 years, then it is fine. But what happened that A dies after 3 years of accumulation of the money? A dies. So over here, what will continue? The life of the transfer is over. So the next is 18 years. Next is a period of 18 years. So this will not continue for 25 years, but rest it will continue only for 15 years, because 3 years is already completed, and transfer in which the life of the transfer is already over as per the clause A of the section 17 of the Transfer of Property Act. So now the property will transfer to B and the condition of accumulation will continue for rest 15 years only, because life of the transferor is already over and after 3 years he is dead now. So the property will continue to transfer for a series of 18 years. So 3 is over. Now rest is 15 years. So the 15 years the accumulation will continue. This is what this section is dealing with. So the next is what? Shall save as hereinafter provided be void to the extent to which the period during which the accumulation is directed exceed the longer to the aforesaid period. So after the lifetime of the transferor or the 18 years is whichever is maximum is ended, the next will be void. Now come to the exception part. This section shall not affect any direction for accumulation for the purpose of the payment of debt of the transferor. For example, C has already given some debts to A, and in return the property is mortgaged to C, but the property is given to transfer to somebody else, that is B, as a person. So now until and unless the debt is over, this section will not prevail. The next is 2. The provision of the portion for the children or remoter issue of the transferor of any of the other person taking any interest under the transfer. So if the transfer and the condition of accumulation is for the benefit of children, basically, that my children will get the maintenance from that property, in that case, or any other remote issue for the transferor or any other person taking interest in this. So if any other person have interest in that property, in that case as well, this will not prevail. The section 17 will not prevail. These are the exception basically. The third point is the preservation or maintenance of the property transfer. So if A put a condition that from this property, the 10% of the income that you've accumulated, you have to put it for the maintenance of the particular property. In that case also, this section will not prevail. So overall over here, that the section 15, 16 and 17 I have already dealt, and 18 also. So in the next slide, in the next lecture, we will be dealing with section 19 and onwards. Thank you for this lecture. Thank you everyone.